y'all got a lot of information about the federal Title IX regulations surrounding sexual harassment. We're going to focus out a little bit now and go into a broader discussion around power-based violence and the state requirements that were recently passed in the legislation and are now reflected in the Board of Regents uniform policy, and focus on creating a safe campus culture. There may be some overlap. You might hear a couple of things more than once, and that's all to the good. The more it's reinforced, it reflects the emphasis and the importance of the subject matter that we're dealing with. And there is, frankly, a lot of overlap between the federal requirements and the state legislation, power-based violence as well. And the gremlin has not quite left yet because I can't seem to advance the slides. Okay, so first let's talk about the uniform policy that the Board of Regents just adopted last Monday. It is a comprehensive policy with a comprehensive scope that focuses on power-based violence, which is really a very broad concept. It is a term that is much broader than Title IX's definition of sexual harassment. It is also much broader than just sexual misconduct, and in fact is broader than even gender or sex-based misconduct. There is not necessarily an element of gender-based motivation or sex-based motivation as a required element of power-based violence. It really is any form of interpersonal violence in which a person uses their power over another, whether that power comes from sex or gender or physical power or institutional power to coerce behavior on the part of another. It is any form of interpersonal violence. And also please note that it's not necessarily just physical violence either. Power-based violence, the definitions pretty clearly extend to verbal harassment and sort of emotional harassment and all those kinds of things. There does not need to be a physical element to it. Now, when power-based violence meets the criteria specified in the Title IX regulations that we spent a lot of time talking about earlier today, it's got to be addressed under the Title IX formal grievance procedure and not this overarching power-based violence policy to the extent that the processes differ between the two policies. Now, put together, the Regents and Louisiana's public post-secondary education systems and the institution's policies and procedures are intended to ensure that students that are impacted by this kind of power-based violence have an avenue to seek redress, investigation, and adjudication through a process that is prompt, thorough, and equitable. Now, we're going to be using a lot of terminology during our session, and that terminology can have different meanings in different contexts. For instance, sexual harassment under Title IX, as you learned earlier today, has a very, very specific definition. Meanwhile, the term sexual harassment is also included in our new state law as a form of power-based violence, but that definition is different than the federal regulatory definition. So please keep these distinctions in mind. Now, there are three categories of misconduct that meet the federal regulatory definition of sexual harassment. The first is the quid pro quo harassment that uses an unwelcomeness standard. The DOE interprets this broadly so that quid pro quo harassment can be implied from the circumstances, such as when there's a power differential between a professor and a student receiving a grade in a professor's class, for instance. So a professor can engage in quid pro quo sexual harassment with respect to a student by dangling the threat of a bad grade or withholding a recommendation or whatever from that student. The next category is sexual assault, dating violence, domestic violence, and stalking, as those terms are defined in the Clery Act and the Violence Against Women Act. I'm sure all of your institutions and systems are very familiar with the Clery Act and the Violence Against Women Act. Sexual assault includes a lot of types of physical sexual violence, and the other three definitions include many types of conduct that is not inherently sexual or gender motivated in nature, just like power-based violence also extends beyond behavior that is sexual or gender motivated in nature. And then finally, we have the catch-all, where the behavior is so severe, pervasive, and objectively offensive that it has the systemic effect of denying access to an institution's programs or activities. That standard is borrowed from the elements of a student-on-student sexual harassment claim under the Davis case. And for misconduct to meet this category, it's got to meet all three of those requirements. It's got to be severe, pervasive, and objectively offensive. That is a high standard. And a lot of student misconduct that schools have traditionally considered to be sexual harassment will no longer meet that regulatory definition, but it will very likely meet the definition of power-based violence under the state statute. For instance, a lot of student verbal harassment won't fall within any of these categories because it's just not severe enough or it doesn't meet some other criteria. And if the student's verbal harassment does meet the definition of sexual harassment, it would have to likely be under that Davis standard of severe, pervasive, and objectively offensive. Now, of course, schools can build out their codes of conduct to address conduct that doesn't meet these requirements. Our power-based violence statute and our uniform policy does just that. Now, power-based violence that is not covered by the Title IX grievance procedure that we went through earlier today, such as off-campus power-based violence alleged to have an on-campus effect, that happens not infrequently, or occurring during a study abroad program, so it doesn't meet those geographic requirements of sexual harassment under Title IX, can be addressed through the broader uniform policy. Now, as we mentioned, let's drill down into what power-based violence means. As I mentioned, violence is not limited to colloquial violence, the way we use that term as in physical violence. It encompasses a significant amount of conduct, and most complaints that institutions receive are going to be adjudicated under these definitions rather than the Title IX sexual harassment definitions. Domestic abuse, for instance, shall include any threat to act that is intended to coerce, control, punish, intimidate, or exact revenge on any other party. It includes family violence as defined under state law, dating violence as defined under state law, which does not have a sexual or gender-based motive underlying it, is also a form of power-based violence. Non-consensual observation includes things like voyeurism, video voyeurism, non-consensual disclosure of a private image like revenge porn, peeping Tom activities. Sexual assault is a very broad definition as well. I think we're all pretty familiar with it and have a good working knowledge of it, including things like sexual battery, female genital mutilation, intentional exposure to HIV, obscenity. These are all defined in state law as well. And then sexual exploitation means an act attempted or committed by a person for sexual gratification, financial gain like pimping or prostitution, or other advancement through the abuse of another person's sexuality. That is well defined in the law. Stalking, cyber stalking are also defined in the law. Unlawful communications, there is a link to the state statute that defines unlawful communications, and that can be something like a series of hang-up calls intended to harass, or sending profane or obscene text messages, or unwanted images, that kind of thing. And then, of course, sexual harassment, differentiated from Title IX sexual harassment under power-based violence as well. Long story short, there are lots of ways to commit power-based violence under the law. The examples that are listed out for you are not intended to be exhaustive, but they are explicitly pointed out in the state statute and therefore are included in the uniform policy. So with that foundation about what power-based violence is, I want to turn over to my colleague Jeff to take us through the next portion.
Hello, everybody. At this time, we want to discuss some of the key terms that will be used throughout the policy and throughout this presentation today. First, we'll discuss a reporter. A reporter is essentially a person who reports an incident of power-based violence to the school. You have first-party reporters, who would be somebody who reports an incident and was an alleged victim of power-based violence or has been impacted or affected by an incident of power-based violence. You also have third-party reporters, who would be people who report incidents of power-based violence of which they have knowledge, but happened against somebody else. As we're going to discuss later on in the presentation, there are a lot of mandatory reporting obligations on school employees. And you may find that a lot of your institution's employees become third-party reporters on a frequent basis. Next key term would be formal complaint. And this is essentially what begins the investigative and adjudicative process. A first-party reporter would file a written and signed document with the Title IX coordinator describing an incident of power-based violence, indicating that they wish to take further steps, such as an investigation or hearing. And of course, if that report or if that formal complaint meets Title IX's jurisdictional requirements, it would need to be addressed through the formal grievance process under Title IX. Next key term is a complainant. We've touched on this earlier today, but the complainant is essentially the alleged victim of an incident of power-based violence, similar to the definition we discussed earlier in the Title IX portion of this training session. You can have a first-party reporter or other person otherwise affected by power-based violence would qualify as a complainant. And under the Title IX process, a person who is alleged to be the victim of Title IX sexual harassment would, of course, be a complainant. Respondents, this is essentially the alleged perpetrator of an incident of power-based violence. Under the Title IX process, the person who is alleged to have engaged in conduct constituting sexual harassment would also be considered a respondent. We'll spend a good bit of time talking about the processes and procedures for complaints regarding power-based violence and the other obligations related to them. But the uniform policy also puts a great deal of emphasis on prevention and safety education. Now, each school's administration will need to consult with campus and local law enforcement agencies to develop and distribute information to students about power-based violence, campus safety, and internet and cell phone safety. This would also include information about online content that might pose a potential threat to school and campus community safety. This information would need to include how to identify and prevent power-based violence, how to detect potential threats, and that would include potential threats through online activity and social media, how to report power-based violence, crimes on campus, student code of conduct violations, and other possible threats to campus safety, where to find reports about campus safety. The reporting process for potential threats should include a standardized form that has the following information: the name of the school, person, or group threatened, the name of the student, individual, or group that posed the threat, the date and time of the threat, and the manner or method of the threat, along with any available information or documentation of the threat. For example, a social media posting, a printout of the threat, threatening post would be helpful to be included. Lastly, the reporting process also needs to include a process for allowing anonymous reporting and for safeguarding the identity of the reporter. And we'll touch on some of those details later. We discussed retaliation earlier today, and the uniform policy flatly prohibits it. Retaliation, you need to think of retaliation broadly. It includes, but is not limited to, intimidation, harassment, threats, or other adverse actions against a reporter, the parties, or witnesses. Schools also may not retaliate against persons who make good faith reports of what they believe to constitute power-based violence. Again, the key thing there would be whether the report was made in good faith. It would also, schools may not retaliate against individuals who cooperate with an investigation or proceeding under this board policy, or who oppose conduct they believe violates the policy. An important caveat, as we touched on a second ago, is anyone who knowingly makes a false accusation may be subject to investigation and disciplinary action, including expulsion or termination. With that, I will turn it back over to Nina to discuss some of the details about the process.
Thanks. So as we go through the nuts and bolts of this uniform policy, I think you'll see an emphasis on three things. One, an emphasis on prevention of power-based violence. So really emphasizing that safety education for the student body and the faculty and the entire institution's community. The second is readily available reporting mechanisms coupled with very significant reporting responsibilities on the part of employees and institutions up the chain. And then finally, appropriate investigative and adjudicative responsibilities to address incidents of power-based violence as they occur. Taken as a whole, I kind of conceptualize this as a 360 prong approach of a comprehensive campus safety strategy to address power-based violence. So if you sort of keep that concept in mind as we go through the nuts and bolts, I think the process becomes clear, it makes sense, it emerges as a holistic, cohesive strategy. So when we're addressing power-based violence or sexual misconduct, this should be a very familiar process to all of you. A report begets an investigation, begets adjudication and resolution. So when we talk about reporting power-based violence, to make a report, any reporting individual can report the incident to your institution's Title IX coordinator or deputy coordinator. And you as institutions are required to make that contact information readily available, as well as methods for reporting power-based violence. And at a minimum, institutions need to allow for reporting in person, reporting by mail, or reporting by email as well. Now, after making a report, an individual can choose to file a request and make a formal grievance and pursue resolution under a very formal process, either under this policy or if it meets the Title IX federal jurisdictional definition under that formal grievance procedure as applicable. Or they can choose to proceed and seek an informal resolution involving a respondent. They can choose to be involved or not be involved in an institution's investigative and related proceedings, or they can choose to end their involvement in the process. When a reporter makes a report, we kind of like to let them be the master of their fate to the extent that they can, and to the extent that we can allow for that to keep our campus community safe. Institutions do have to provide an online reporting system to collect anonymous disclosures of incidents of power-based violence and crimes as well, and to also track patterns of power-based violence and crimes on campus. You'll learn later as we go through the policy that there are very significant up-the-chain reporting requirements and reports that are very public-facing that need to be made by institutions, systems, and the Board of Regents. So it's important to collect that data. The online system also needs to include information about how to report an incident of power-based violence to a responsible employee. We're going to define that in a minute, and law enforcement, and also how to contact a confidential advisor. Now, we do so much of our business these days and get so much of our information online, and our campus communities are obviously no exception to that. We also all know that some websites are a lot easier to navigate and a lot easier to find information on than others. As a best practice, we encourage you to make your Title IX landing page visible, easy to find, and full of easily accessible and relevant and required information for your campus communities. I know, for instance, that there are organizations that work very closely with what are called wayfinding experts that maximize ease of use and navigation on websites and even in physical spaces around your campuses or in airports and whatever. And it's all about making the experience easier for the user so the user can get the information that they're looking for with a minimum of effort. So if your institution has the capacity to do so, you may want to consider doing something similar. The reporting obligations in the state law and therefore in the uniform policy are robust. Any employee, let's define responsible employee. Responsible employee is any employee who receives a direct statement regarding or witnesses an incident of power-based violence committed by or against a student. And that responsible employee has some obligations. Primarily, that obligation is to promptly report the incident to the institution's Title IX coordinator. And they've got to include information such as the identity of the alleged victim, the alleged perpetrator, the type of power-based violence or retaliation alleged, any other information about witnesses' location, date, time, and any other relevant information. Responsible employees, the category is large. Under state law, it includes administrative officers, officials, or employees of a board or institution, anyone appointed to a board or institution, anyone employed by or through a board or institution, and anyone employed by a foundation or an association related to a board or institution. So that's basically everybody. The only explicit exception is an employee designated as a confidential advisor or an employee who has a privileged communication with the student as provided by law. So think of, I don't know if students would ever have attorney-client privilege conversations with an institution employee, but they might have patient-therapist privilege or priest-penitent privilege. Now, students are generally not responsible employees unless the student works for the institution in a position such as a teaching assistant or a residential advisor. Now, there are some state law exceptions as to when a responsible employee, is not obligated to report an incident of power-based violence. And in the law, that is when, if during a public forum or awareness event in which the individual discloses an incident of power-based violence as a part of educating others, there is no obligation to report. So think about those hearings that happened in the state legislature over the summer as part of the development of these pieces of legislation. If the disclosure is made in the course of academic work consistent with the assignment, if a student has an assignment to write a personal essay about a life-changing event for them, perhaps, or they are doing some research on power-based violence, or if the disclosure is made indirectly, such as in the course of overhearing a conversation, there is no obligation to report. Now, note that while there is no obligation to report, there is no prohibition against reporting either. Now, if an employee believes an individual may intend to share information regarding an instance of power-based violence, the employee should seek to confirm that the reporting party understands their obligations as a mandatory reporter. If a reporting party would prefer to speak with a confidential resource, institutions can make that happen. So students can be directed to those confidential advisors or mental health counseling centers if they prefer to have a confidential conversation without sort of triggering the machinery of obligations under this process. And our responsible employees do have some skin in the game. There are consequences. Responsible employees who are determined by an institution's disciplinary procedures to have knowingly failed to make a report shall be terminated. Likewise, if a responsible employee is determined via the institution's disciplinary procedures to have made a report with the intent to harm or deceive, or made a knowingly false report, they shall be terminated too. So all of our institution employees, our board members, everyone up and down the line, they need to understand these obligations to report and the consequences for failing to do so because they are significant. Now, in accordance with state law, and unless waived in writing by the alleged victim, the identity of an alleged victim of an incident reported under the state statute is confidential and not subject to disclosure, unless the person employed by or under contract with the institution to which the report is made, they can disclose it if necessary to conduct the investigation of the report or to conduct any related hearings like an informal resolution or an adjudication process. It can be disclosed to a law enforcement officer as necessary to conduct a criminal investigation of the report. And you'll learn later about our MOU responsibilities to have agreements with local law enforcement. They can be disclosed to the person alleged to have perpetrated the incident to the extent required by law. Certainly, if we're going to investigate an incident, the person who is being investigated needs to know what they're being accused of and by whom, or to a potential witness to the incident as necessary to conduct an investigation of the report. And consistent with FERPA's prohibition on redisclosure of confidential information, any person who receives another person's confidential information solely as a result of participation in an investigation or proceeding under the policy is prohibited from using or disclosing that confidential information outside of such forums without express consent or for any improper purpose. Now, this provision only applies to other people's confidential information. A party can disclose their own confidential information however they want. And the provision also does not apply to any information that's learned outside of an investigation or proceeding under this policy. If they just learn information about another person through social media, because people put a lot of things on social media these days, this confidentiality provision does not apply. Institutions also have an obligation under state law and the uniform policy to designate confidential advisors. These are individuals such as healthcare staff, clergy, staff at a women's center, or other such categories and similar employees. And each institution's website needs to provide contact information for obtaining a confidential advisor. So if a student wants to talk to someone who's a confidential advisor and not worry about talking to a mandated reporter, they can know who to go to. The confidential advisor to an alleged victim of power-based violence has some responsibilities to that alleged victim as well. And they need to inform the alleged victim of the following. They need to inform them of their rights under federal and state law and the institution's policies, the alleged victim's reporting options, including the option to notify the institution, go to local law enforcement, any other reporting agencies, or options that might be available to him or her. Potential consequences of those reporting options to the extent that they are known. The process for investigation and disciplinary proceedings of the institution. If an alleged victim wants to make a report, it's only fair that he or she understand what the process is going to be as a result of that. The process of investigating and adjudication of the criminal justice system as well. It's only fair that they understand that process before they volunteer to put themselves in it. The limited jurisdiction, scope, and available sanctions of the institutional student disciplinary proceeding. And this is why it's so important for institutions to spell out what potential sanctions are. And that institutional student disciplinary proceedings are not a substitute for the criminal justice process. So you can have parallel processes going on at the same time. Confidential advisors need to let an alleged victim know of potential reasonable accommodations that an institution may provide to an alleged victim. It is not unheard of for an alleged victim to not really want an investigation or adjudication. They just want some accommodations to feel safe. And that's an option for them as well that they should be aware of. And the name and location of the nearest medical facility, where an alleged victim can have a rape kit administered by someone trained in sexual assault forensic medical examination and evidence collection, and information on transportation options and available reimbursement for a visit to such a facility. Now, the institution has to appoint an adequate number of confidential advisors, and the regents will determine the adequate number of advisors for each institution based upon its size. There is a provision in the statute that says each institution that enrolls fewer than 5,000 students can partner with another institution in their system or region to provide the services of confidential advisors, but it's not a substitute for actually providing this service. The confidential advisor is authorized by the institution to liaise with appropriate staff in the institution to arrange reasonable accommodations through the institution. The confidential advisor is also authorized to accompany the alleged victim when requested to do so by that alleged victim to interviews or other proceedings of a campus investigation and institutional disciplinary proceedings. Now, institutions can, of course, choose while a confidential advisor may be allowed into investigative proceedings, they may be prohibited from actively participating or interfering with those proceedings. Confidential advisors need to advise the alleged victim of and provide written information regarding both victims' rights and the institution's responsibility regarding orders of protection, no contact orders, restraining orders, or similar orders that can be issued by the court system and the criminal justice system. Additionally, confidential advisors are not to be obligated to report crimes to the institution or law enforcement in a way that identifies an alleged victim or an accused individual unless otherwise required to do so by law. They are confidential advisors for a reason. And to the extent authorized under law, they are to be allowed to provide confidential services to students. Any requests made for accommodations made by a confidential advisor should not trigger an investigation by the institution. It's just a request for accommodations. And of course, they are not considered responsible employees subject to reporting requirements. So if you have designated employees as confidential advisors, they are not subject to the mandated reporting requirements. Now, in addition to individual employee reporting requirements surrounding individual instances of power-based violence, there is pretty significant up the chain reporting of data. Specifically, the Title IX coordinator twice a year needs to submit to the chancellor of his or her institution a written report on reports received in accordance with the information required in Appendix B of the uniform policy. That information gets floated up to the chancellor, and then the chancellor of that institution needs to submit a report to the management board and system present within 14 days of that same information. And then the system president needs to submit a system-wide summary report within 14 days of receiving reports from the chancellors to that system's management board. That report also needs to be published on the system's website. Then the system management board submits an annual system-wide summary report to the regents by December 31st of every year. And that gets posted on a website as well. And then finally, the Board of Regents annually submit a report to the governor, the president of the Senate, the Speaker of the House of Representatives, and the Senate and House Education Committees that includes statewide information, along with any recommendations for legislation. And that report is published on the Regents website as well. So as you can see, there is significant up the chain reporting about holistic data, about power-based violence. These reporting requirements are robust. They are public facing. That is intentional. It's making sure that our communities are informed about what is going on our campuses, and that we're keeping a beat on what's happening on our campuses, and that we're addressing what's happening on our campuses. Another provision of the uniform policy speaks to transcript withholding, notation, and communication. And I will say that this provision was the subject of some very robust conversation between the Board of Regents and the system council, and we had very rich discussions that I think led to a really good landing place. So at a minimum, for a student who is the subject of power-based violence formal complaint and who attempts to transfer to another institution, an institution is defined as a public post-secondary institution. The sending institution, the institution from which the student seeks to transfer, shall either withhold the transcript of the student or place a notation on the student's transcript. And if the sending student does not know whether the student seeks to transfer to another institution or whether they're just leaving, the student's transcript shall either be withheld or notated. The sending institution needs to notify that student that their transcript has been withheld or notated, and of the appeals process that is laid out in the uniform policy to have the hold or notation removed. And either the transcript is withheld or the notation remains on the transferring student's transcript until the institution makes a determination that the transferring student is not responsible for power-based violence, or the transferring student prevails in a request to appeal the withholding or the notation pursuant to the uniform policy, whichever occurs first. So for transferring students who are the subject of a pending investigation, the notation on the transcript is going to read either administrative matter pending, or if the institution wants to use another notation, they can use another notation that is sufficient to place the receiving institution on notice and trigger an inquiry regarding the notation directed to the sending institution. The intent of this is when a receiving institution receives a transcript and they see administrative matter pending, they don't know what it's about. It could be anything from I didn't pay my student activity fee to I took the campus golf cart for a joyride to I am accused of rape and literally anything in between. So it doesn't provide a lot of detail. It doesn't provide any detail. It just provides enough to trigger the receiving institution to pick up the phone and call the sending institution. For a transferring student for whom a final decision has been rendered and that student has been found responsible for power-based violence, the notation on the transcript is going to read either student found responsible in violation of code of conduct, or some other notation that the institution can choose, but it's got to be a notation sufficient to place the receiving institution on notice and trigger that same inquiry. If the student is not found responsible, if they go through all this, they transfer and ultimately they are found not responsible, the sending institution needs to remove that notation and send an updated, clean version of the student's transcript to the receiving institution if there is one and if it's known. Now, state law requires that all Louisiana public post-secondary institutions implement this transcript withholding notation and communication policy. It does not require that non-public post-secondary institutions do so, but our uniform policy encourages them to do so. And with that, I'm going to turn it back over to Jeff to discuss investigation and adjudication of power-based violence complaints.
When a formal complaint comes in, the Title IX coordinator has an initial very, very important responsibility, and that's to screen the complaint to see if the Title IX jurisdictional requirements are met. If the Title IX jurisdictional requirements are met, then the complaint needs to be investigated and adjudicated through the formal grievance process. If any of those jurisdictional requirements is not present, then the complaint can be investigated and adjudicated through the broader policy available for other types of power-based violence. Once the Title IX coordinator receives the notice of the power-based violence, the Title IX coordinator needs to implement supportive measures and initiate an investigation as necessary. The form of the investigation will vary depending on whether the misconduct meets the jurisdictional requirements of Title IX. Once the Title IX coordinator gets the complaint, first, after we do that initial Title IX screening, the next thing is to contact the complainant. And during this meeting, it's very important to keep in mind what you're dealing with. Power-based violence can be a traumatic experience for somebody. So the Title IX coordinator should focus not just on delivering information and being a conduit of a bunch of procedural requirements and procedural rights and just reading off the list, but you want to actually connect with a person so that they hear, understand, and process what you're saying. Now, the content of that you're going to need to discuss, you're going to tell them about their options to have an advisor. You're going to make sure that they have copies of the relevant policies. You're going to explain the process for filing a formal complaint, their rights and responsibilities as a party. Explain to them how the investigative and adjudicative process works. Help them understand the difference between the procedural differences under the Title IX process versus the power-based violence process, and what types of conduct qualify for those different types of treatment. Be sure to tell them to preserve evidence. Again, this is where you need to be mindful of the state of mind the alleged victim is in. So you want to make sure that they think to preserve things like text messages or screenshots of social media activity or other types of evidence that might be helpful and revealing during the course of the investigation. You also want to discuss the availability of supportive measures, and that goes with or without the filing of a formal complaint. And you want to make sure that you engage with the complainant to understand what their preferences are on how the matter is resolved. Do they want an investigation? Do they want a formal process? Might they be interested in an informal resolution? You want to make sure you tell them about the prohibition on retaliation and how to report the incident to campus police if they so choose. Now, this discussion on supportive measures, it's largely the same as it is in the Title IX context. We're talking about non-disciplinary, non-punitive, individualized services that the school offers as appropriate and reasonably available without fee or charge to either the complainant or the respondent. You don't want to just offer supportive measures to alleged victims only. You also need to offer supportive measures as appropriate and reasonably necessary to the respondent. And this goes regardless of whether a formal complaint has been filed or signed. This is one of those areas where an ounce of prevention is worth a pound of cure. A lot of times people just need help, and this is a good way to do that with your students. Now, formal complaints are filed with the Title IX coordinator. They can be filed in any type of form, paper, electronic, in person, or in a meeting. Please note that if the formal complaint, again, if it satisfies the Title IX jurisdiction requirements, then it's going to be subject to that formal grievance process under Title IX. Now, the next series of slides we're going to cover will be discussing how the investigative and resolution process works outside of the Title IX process. So the next thing we need to do is give notice to the respondent. You want to give them notice of the formal complaint, make sure they know about the availability of an advisor, and within 7 days of the respondent receiving that notice, the respondent should arrange to meet with the Title IX office, and the Title IX office needs to provide them information, the same information that it provided to the complainant, which we discussed earlier. After reviewing the formal complaint with the Title IX coordinator, the respondent may choose to end the process by accepting responsibility. If that's the case, then the appropriate decision maker will determine an appropriate sanction. That might be a warning, it might be something more severe. If the respondent does not accept responsibility, then the matter would proceed to an investigation. Important thing about investigations, they should not be conducted by the Title IX coordinator or the decision maker. Courts are very hostile to what is called the single investigator model. And essentially the single investigator model is where one person is the judge, jury, and executioner. We need to keep these roles separate to maintain credibility and integrity in the process. The investigation begins with an intake meeting. And during the intake meeting, the investigator needs to be interviewing parties and witnesses, reviewing law enforcement documents such as a police report, reviewing relevant student and employee files, and gathering and examining other relevant documents and evidence. For example, you might have relevant evidence in somebody's social media activity. It might be a good opportunity for the investigator to hop on Facebook or Instagram and see what's been posted by the parties and witnesses you've learned of at that point, and take screenshots or print-offs of the content before it gets lost or deleted at some point. Next, the parties need an opportunity to provide statements, identify witness, and submit other evidence. And throughout this process, advisors have a limited role. They may not participate directly in the investigation, hearing, or later informal resolution process unless the Title IX formal grievance process applies. At the conclusion of the investigation, the investigator is going to prepare a written report and deliver that report to the Title IX coordinator. And the report should summarize and analyze the relevant facts with reference to the supporting evidence. Don't just make conclusory statements, but explain what evidence supports that particular finding. This makes the report more useful and helpful to the Title IX coordinator and the ultimate decision maker. The Title IX coordinator is going to review that report to ensure that it was conducted in a prompt, impartial, thorough manner, and that it was consistent with the institution's policies. Parties will receive an opportunity to submit comments on their own statements within 5 days after they're provided with copies of those statements or summaries. And the final report should include a summary of the investigator's impressions, as well as provide a context for the evidence collected. But this is very, very important. It should not make a final determination or any kind of suggestion of how the decision maker should decide the case. The investigator gathers the evidence and summarizes the evidence, but it's important that these roles are compartmentalized. It is the decision maker's job to determine whether the respondent is responsible or not responsible. The investigator is simply gathering and presenting evidence to facilitate that decision-making process. And once the final report is completed, it should be provided to the parties simultaneously. A good time when meeting with the parties initially, there may be some interest in conducting resolving it through an informal resolution process rather than a hearing. The Title IX coordinator should make an initial determination about whether he or she thinks informal resolution might be appropriate and discuss that as an option with both of the parties. Informal resolution, it's a remedies-based non-judicial process that's designed to eliminate or address power-based violence. The aim is to assure fairness, facilitate communication, and maintain an equitable balance of power between the parties. And it's a purely voluntary process, and consequently, you cannot compel participation. If both parties agree, then the investigation stops, and we see what happens through the informal resolution process, and it may be terminated by either party at any time for any reason. The next, we're going to talk about formal resolution. For non-Title IX proceedings, each school has a lot of discretion in designing their formal resolution process. The big thing to keep in mind here is that we cannot have a single investigator model. The Title IX coordinator, the investigator, and the decision maker need to be separate people. And of course, you can have one or more decision makers deciding the process. One thing I would recommend is having an odd number of decision makers so that if you have any kind of disagreement over the finding of responsibility, you're able to reach a majority without anything resulting in a gridlock. Once the decision maker makes a determination of responsibility, they'll assess appropriate sanctions if they find the respondent to be responsible. Schools need to describe the range of potentially available sanctions under their policy. And it could be a wide range, anything from a warning up to expulsion. The sanctions need to be tailored to the individualized facts of each case and based on the evidence presented during the hearing process. The policies have provisions for appeals. The important thing with appeals, they need to be limited and they need to be clearly defined, because what you see in a lot of schools' policies are that the grounds for appeal get rather murky. Common grounds for appeal that a lot of institutions use would be a procedural irregularity that affected the outcome of the matter. It's important that we have the requirement that it affect the outcome of the matter, because that's what makes the procedural irregularity material. If somebody was to appeal based on a temporary termination of video feed during a virtual hearing, that might be a procedural irregularity. But if the video feed was able to be corrected in a timely manner, then we would not have anything that was material or anything that affected the outcome. Another common ground, new evidence that was not previously known or knowable to the parties. If there was an impermissible evidence that is material, that would be sufficient to alter the outcome of the decision. If there was an impermissible conflict of interest or bias that affected the outcome. If the decision maker committed some major substantive error, like applying an incorrect standard of evidence, say applying clear and convincing evidence when the proper standard was a preponderance of the evidence. And lastly, if sanctions are disproportionately high or low relative to the nature of the misconduct at issue. Both parties need to have written notice that an appeal has been filed. The appellate grounds need to be equally available to both parties. So we can't just say complainants, or you have these grounds for appeal, respondents, you have these grounds for appeal. The grounds for appeal have to be applied equally to both parties. The appellate decision maker should not be the same person who originally decided the case. We need independence and in this process. And again, that this gives the process integrity and credibility. Both parties need reasonable, equal opportunities to provide written statements in support of or against the outcome on appeal. And the written decision describing the result and rationale on appeal needs to be provided simultaneously to both parties. With that, I'm going to turn it back over to Nina to discuss some of the other state law requirements under the new legislation.
So there are a few other odds and ends in the state law that we wanted to highlight for you as well before we leave today. First, institutions are required to conduct PowerBased Violence climate surveys, starting with the 22-23 school year, and then at least every 3 years thereafter. Institutions administer other surveys with regard to campus safety, and institutions often do. The PowerBased Violence Climate Survey can be included as a component of that, so you can sort of get a 2-for-1. Those survey results need to be reported to the system management boards and the Board of Regents. And institutions also need to publish those survey results in a prominent, easily accessible location on an institution's website. So you're seeing all of these public-facing posting and reporting requirements. And one way to perhaps fulfill that is to have a dedicated landing page on your institution's website for all of this kind of information. Additionally, each institution needs to publish on its website a semi-annual security report to contain updated campus security policies and campus crime statistics. That report needs to be updated and posted twice a year by April 10th and October 10th of each academic year. Again, also posted in a prominent location that is readily accessible from the main landing page of an institution's website. And if an individual campus doesn't have its own website, then the information needs to be posted on the main website of the institution with the campus involved clearly indicated. By February 15th of each year, each institution's campus police department, needs to submit a report containing the information required in Appendix C of the uniform policy to the system president, the institution's chancellor, and the institution's Title IX coordinator. And the chancellor ensures that that report is posted on an institution's website. Also, on or before January 1st, 2022, each institution and law enforcement and criminal justice agency located within the parish of the campus, including the campus police department, if any, the local DA's office, and any local enforcement agency with criminal jurisdiction over the campus need to have a written memorandum of understanding that clearly sets out each institution's and each agency's responsibilities, how information will be shared in accordance with federal and state confidentiality laws. And it's got to include, and it's certainly not limited to, trends about power-based violence committed by or against students of the institution. That MOU has to be executed by all the parties involved. They need to be reviewed annually by each institution's chancellor, Title IX coordinator, and executive officer of the criminal justice agency, and need to be revised as considered necessary. Additionally, each institution's management board needs to institute their own policies, incorporating the policies and best practices prescribed in the Board of Regents uniform policy regarding the prevention and reporting of incidents of power-based violence. The policies at the institutional level have to include certain components with respect to confidential advisor, website accessibility and information, online reporting, the amnesty policy for those who report, training, inter-campus transfers, and victims' rights. So institutions do have flexibility within the requirements of state law and the best practices spelled out in the Board of Regents uniform policy. In addition to publishing the specified reports that we talked about, and there are several of them, institutions also have to include the following information on their websites: contact information for obtaining confidential advisors, reporting options for alleged victims of power-based violence, the investigation and disciplinary proceedings of the institution with respect to power-based violence, the investigation and adjudication process of the criminal justice system with respect to power-based violence, potential reasonable accommodations that the institution can offer to an alleged victim as appropriate, contact information for local, state, and national hotlines to assist victims that has to be updated at least annually, the name and the location of the nearest medical facility where a rape kit can be administered, and each current MOU between the institution and law enforcement, as well as the data publication specified in the policy. So you can see that this is going to be a very robust landing page with a lot of information that's going to be sort of a one-stop shop for your campus community in how to prevent power-based violence, how to address power-based violence, and data surrounding power-based violence at the institution. And I know that we have covered a lot of information in a relatively short amount of time, but that's it. That is the uniform policy from soup to nuts at a high level. That is the federal Title IX grievance process from soup to nuts at a pretty high level. And with that, we are happy to take any questions that you have.
Thank you all for such an amazing presentation. If you have any questions, please feel free to drop them over in the chat, or you can utilize the Q&A function before we wrap up for today if there are no questions. Okay, we have one question that came into the chat. Great information, team. We have talked about addressing and preventing PBV, power-based violence towards students. However, would you mind explaining how this affects employees that are victims of power-based violence?
Certainly. You know, the statute is very student focused. That seems to be where a lot of the energy and a lot of the concerns were about. There is nothing that stops institutions from adopting similar kinds of protections for their employees as well. I'm sure that if any institution did sort of a power map of where power resides within their institution, they will see pretty readily that there are some employee and staff quarters where power resides with respect to other employees as well. So nothing prevents an institution from adopting similar policies.
And that's with respect to the state statute. Under the federal regulatory scheme, though, the idea of Title IX, when it is defining sexual harassment, must pertain to employees. So regardless of whether an employee or a student was the complainant, supportive measures must be required if it reaches those federal definitions. And the adjudicative process is largely the same. As we mentioned at one point, the emergency removal process is different for employee respondents, and there are a couple of other nuances. But for the most part, we're looking at the exact same process, whether employee or student on the federal side.
All right, and we have one more question that has come into the chat, and Dr. Reed, I'll loop you in on this question. How many complaints have been received system-wide within the Board of Regents encompassing all campuses?
How many complaints have we received?
Yes.
Is the question?
How many complaints have received system-wide within the Board of Regents, a total number of complaints? And if for the person who asked the question, is there a specific time frame you're referring to?
Well, let me say this. This is new legislation that requires up the chain reporting and incident reporting. And so we have not had this requirement before to receive this information. And so we will be receiving this information moving forward.
All right, thank you, Dr. Reed. And I believe that is the last question that we have. So before we close out for today, I would like to turn it over to you for some closing remarks.
Thank you so much. Thank you all again for joining by Zoom today. I know this is not an ideal way to do training, but in the fourth surge with COVID, we've got to do this safely. And we wanted to do it as quickly as possible, as close to the fall semester as possible, to the kickoff of the fall semester. So grateful for your participation, your active engagement. Certainly appreciate Nelson Mullins and their team for getting this training stood up 1 week after the Board of Regents special call meeting to approve the policy. And then let me show you a slate of names that I want to personally thank. So as I mentioned, we began meeting with the system presidents and the board chairs 5 days after session. We asked for a collaborative process and for nominees from every system for work team members who would engage with us over a month plus to get the uniform policy and the notation policy stood up. And so these individuals gave of their time, they asked great questions, they really sat with the information, with the legislation, and they shared their expertise. And collectively, their work helped us to get to a stronger, better policy, and certainly a collaborative policy. So I want to really thank the work team members and certainly the systems for sharing that expertise with us. In terms of next steps, the systems will be working on campus policies to be developed aligned to the new Regents uniform policy as required and has been mentioned. We look forward to receiving those policies prior to the calendar year. The system presidents will be working on those. The boards will certify that they are aligned to the uniform policy and then forward them to us. As was mentioned, this is a recorded session, and so it will be a resource to you that we will share, but also for individual board members who had conflicts and couldn't make this training. We will ask that they listen to the training and certify that they did participate and receive the training as well. Finally, I want to thank the system presidents who have been so highly engaged and partners in this work, and certainly the board members for your leadership. I know that collectively you're fully committed to advancing this work necessary to ensure that our campuses are safe and that we have rich educational environments for our students, and that we meet this moment. Regents setting strong policy, and campuses and systems implementing and enforcing policies and procedures, but also educational programs and having a culture that speaks to who we are and what we value, a campus that cares, communities that care and that support our students. So collectively, your efforts will ensure that we have the strongest and safest environment possible for the 200,000 plus students who are enrolled in our institutions here in Louisiana. And for that, we are grateful. So again, thank you for your time, for your commitment, for your service. We really appreciate you participating in today's training. Thanks again.